Will the chairman yield?
Yes, I will, Mr. Grant.
Chairman yields.
Thank you, Denny. Denny, on the pre-K, now there's $786.9 million going into the pre-K program, correct?
Pre-K. What's the pre-K? What? 807, which pre-K? Pre-K. Okay. 800, how much? Yeah, $807 million. $807 million.
I thought it was going to be a really
$10.
small program for a minute. Now, 68% of the pre-K funding is going to New York City, correct?
I don't know that.
Can you ask your brain trust?
Yeah, they don't know.
Okay.
Never mind.
Sorry, Denny.
No, we don't really have the breakdown on that.
Okay. Now,
Because remember, the city puts money in on their money to do their pre-K. And as I try to remind people, remember we in Albany have been voting on this for the last 17 years.
all right, well, the figure that I have is 68% is going to New York City, and the rest is getting divided up around the state. Does that sound plausible?
It could be, yes,
Okay.
because it's on a drawdown.
Okay.
In other words, if upstate had more places, they would get more money. Because that's one of the problems. It's a lot of, you can't just bring in children into a classroom because you have to make smaller toilet bowls. There's a whole lot of things you have to do. So they're very slow in doing it.
Okay.
But once they do it, I think we will give them the money.
Did we get any money to make sure that all the schools get kindergartens?
Yes.
How much money did we add for that?
Yeah, we have money for 5 years for the kindergartens. We have money available for 5 years for the people we have with kindergartens now.
Okay, that's additional money, or is that money
Yes.
we're spending? Okay. Now
That's future year money.
Okay. Now the criminal justice reform that we have in the budget. Now, what you've done here is you had the special prosecutor, and it was for deaths that the special prosecutor, which is the Attorney General's office,
Yes,
now he could take the case away from the local district attorney, correct?
yes,
And even though the local district attorney is going to prosecute the case, he can decide to step in and take the case over.
yes.
Isn't that correct?
That's right.
And they're separately elected officials, the DA.
Yes,
So why are we subverting their authority? That's what they're elected to do. Why are we doing that?
because sometimes the case is such that having somebody on home turf might be a problem, and maybe it would be better for someone stepping back. I think that's one of the reasons. In other words, not being negative to the person who's there, but by the problem or the type of problem, they may just decide to pull it out.
Okay. And now it's not only death, it's an injury. What kind of injuries are we talking about? Is it any injury that a person sustained? Because you realize sometimes people don't want to be handcuffed.
What's the beginning of the sentence?
What you have, conduct investigations into death and injuries of civilians that is caused by a police officer. Okay. Well, the death was the result of an injury.
Yes, as a result of a force. If force is brought on and there's an injury, then
All right.
deadly force.
All right. Now, the other part of this, we're talking about cameras in correctional facilities. A pilot program.
Yes.
Are we doing that right now?
Has it started? We're starting now. No.
And this is body cameras.
Yes.
And who controls the body cameras? Can the correction officers turn the body cameras on and off?
It's up to the doctor. Oh, it's up to Doc's department to make the decision.
of who controls the cameras?
Yes.
Okay. And now, what will happen, some of these videos will be used for evidence, correct? That's what we're looking to do here?
Yes, it's possible.
And to keep the chain of custody, the corrections department are the ones that are going to have to hold on to the cameras, correct? Or the videos, correct?
Yes.
And do you have an estimate of how much that's going to cost
To keep the camera,
to store the video?
yeah. Yeah. The governor has 25 million in the program now, but we're waiting for him to put together his program as to exactly how he's going to do some of these problems. So that may be one of the questions that he'll have to answer.
Now, is this just in one jail, or is this in all the jails, or just a couple jails? How many jails are we talking? Which jails?
It's
State
up to
jail?
the department to make the decisions.
Which department? State Department of
The
Corrections, City Department of Corrections?
The corrections department,
Okay. Which corrections department? State Corrections?
state
City
corrections
State
department.
Corrections. So it'll be in state
Yes,
jails.
yes.
And you know if these videos are foilable?
If they're what?
Foilable.
Foilable. What's foilable?
Freedom of Information Law.
Oh. The governor will have to make those decisions, and they're not been made yet.
Okay. And,
Yeah.
all right, let's move off them. We'll save them for when the governor's proposal comes out, because I know that'll be inadequate. Now, we go to raise the age, criminal responsibility. And right here, we shift, establishes a youth part in the adult criminal court, wherein juvenile offenders will be processed, right? Now, in order to take a case from criminal court to family court, right, it's usually with the consent of the DA. Now, here, it's the court that makes the decision.
Right.
So they take the DA out of the equation? Is that what we're doing here?
Yes. In some cases, yes.
Well, the way it's written, it's the court that decides if it should be switched to family court. The DA has no say, correct?
Yeah, what's that here? The Assembly bill requires the court to consider the recommendations of the DA, but doesn't give the DA a veto. The judge is a neutral arbiter who can hear arguments from both the DA and the defendant, while also considering the factors set forth in statute, and make a fair and reasonable decision based on all of the information available in individual circumstances.
Okay, so we don't need consent to the DA for that anymore.
Yeah.
Now, the other thing we're going to do is they're going to seal past records here, and but not, I think, up to 2 eligible offenses, but not more than 1 felony. They could seal those records, and they could do that retroactively, okay? Can you tell me what felonies they're allowed to seal? How A felonies, B felonies, C felonies?
What, this proposed sealing provisions, this proposal allows a person with 2 prior convictions for certain nonviolent offenses to have these convictions sealed after a waiting period has passed. It also allows the district attorney for the defendant to request a hearing. If the person receiving the sealing is arrested for any crime within 10 years following the completion of their sentence, their sealed offense will be unsealed.
All right, but which felonies are we talking about? Are they A felonies? Are they B felonies? Are they C felonies? Are they violent felonies? Are they sex crimes? Right? Are they A, B,
These are
C
nonviolent.
felons?
These are all nonviolent folks.
They're all nonviolent?
Yes, nonviolent.
Okay. But do they include A felonies?
Say that again.
A felonies.
Yes.
We designation A felony, B felony.
Yeah,
C
yeah, it
felony?
could be an A, yeah.
Do they include
They
A
can
felonies?
do that.
Okay. And now we expand existing youthful offender law to allow persons up to 20 years of age to be given youthful offender status in this legislation. Is that correct?
Yes.
All right. And then we're raising the age now. And if a person, correct me if I'm wrong,
You're wrong.
requires all juvenile offenders committed to OCFS for committing a crime prior to their 16th birthday, they're going to be put in a youth facility, right, under this?
Yes.
And they stay in that youth facility till they're 23?
Up to 23, yes.
So we're going to put
23.
22 and 364 days in with 13, 14, 15, and 16-year-olds?
Yeah, when you put it that way, you know. But yes.
Okay. And now we have a facility, we're closing facilities, but now we're going to open facilities,
Yeah.
okay, for youthful, for youths that are incarcerated, right?
Yes.
And how many facilities are we going to open?
We're not opening anything. Yeah, we're not going to open anything up. We're going to be using ones that are open now.
Okay.
We're not opening.
And are we putting female offenders and male offenders in the same institutions?
No.
They'll be in separate institutions.
Yes.
There's your answer to that. Okay. Oh, and in this legislation, and tell me if I'm reading this wrong, but if a child brings a gun to school and he's under 18, he can't be charged as an adult?
If he brings, you mean he charged having the pistol? Because he could shoot somebody, he'll be charged.
Well, he can, according to this legislation, would raise the age. If a child, 17 years, 365 days old,
Yeah.
brings a loaded pistol to school, right, he would go to family court, correct?
Yes.
Okay. And he couldn't be charged as an adult here.
That's right. Hold on just a minute.
Bring it up.
Yeah, well, well, again, you're just talking about him having the gun, period. The minute he does something with the gun, then there's a different program and there are different answers.
Yeah, but he can bring a
But if he just has the gun and you pick him up with the gun, then that's okay.
Okay, that's okay?
Yeah, no, it's not okay. The NRA will immediately call me in and put me in if I said that.
Okay. Danny, thank you very much.
Sure.